You need to have a HIPAA waiver form. You need to have a HIPAA waiver form. Wait a minute. Where's my HIPAA waiver form? We draft the language directly. Hi, Jeff Masacci, the Plain English Attorney, and this video is for our document review course. This is kind of specifically being put together for our clients as a kind of overview video of the different documents, a kind of refresher when going from the estate summary over to the document review. So at that point, we've had the summary. We've sent you the documents to take a look at. This is kind of a companion piece in case you want more information on the different documents and what they're supposed to do. And we're also going to try to answer some of the most common questions at the same time. Now, this isn't some big required reading and you've got to go through these videos. No, this is more about if you want more information up front, chances are maybe 85 to 90% of the questions you're going to have, they might be answered in this course. We're also going to potentially put this out separately as YouTube videos or shorts. So this is for my clients. It's not mandatory. And just remember, the document review meeting is a kind of last and final check on the document. So when we have that document review meeting, we're going to go through any of the changes you may need, any corrections, answer all of your questions so that when you come to the signing meeting next, that's it. That's all we're doing. We're signing your documents and getting you on your way. If you think it's important for educational videos like this to get out there, then please help us out by subscribing to the channel. So I'm going to cover the most common questions in advance for those particular documents. Now, here are things to not worry about. Don't worry about the dates in the documents. Look, they're going to be automatically updated for the date of signing when we print them out. And don't worry about blanks that appear in the documents unless they're actually highlighted, most likely in yellow. That's us waiting on information from you that didn't get in the process. So when we put together the documents kind of up front and then there's the summary, we were missing that information. We just want to make sure that we put that information in, but the other blanks, in a lot of cases, they're just meant to be there for you to fill in later. Now, we're also going to do an AI audio version of my book, the 222 must-have provisions that are in just the trust. Now, this is the trust from the estate planning source, but we have a lot of similar clauses and phrases, and I even try to keep some of the numbering of the sections consistent. If you really want to dig in and go into the trust and go through, look, it's all going to be there. But again, this is not something that's mandatory. It's just there for you if you want it. All right. So with the revocable living trust, the main sections that you should focus more on, Section 2 is on the family situation. It's got the official trust name. And again, don't worry about any of the dates. Section 4, this is where we're listing the trustees. So these are the people that you've chosen to handle financial things for you in case you can't. And so all those names are listed. And here's how trustees get replaced. That's in Section 4. Section 14 for individuals, 18 for married couples, or Section 16 for unmarried couples in the trust. This is the allocation and distribution terms of the estate. So this is where, when we went through the summary, it kind of gave the summary of here's how things get distributed. This is the actual language in the document. It may sound a little wordy or convoluted, but it's actually extremely precise the way it's worded. But you can walk through and see if this person passes on, here's where this goes. If this person passes on, here's where this goes. But it's also important to realize a couple of things here. It's not just how much is allocated. It's when it goes out of the trust into the beneficiary. So when references are made to a share being distributed in accordance with the section per stirpes, all right, that's the catch-all for when a named beneficiary, usually the named beneficiary passes on, you may have already distributed that outright, but this is for their descendants. For example, it's extremely common for a person to list, I want my adult children to receive everything. They're all responsible. We want it done outright. But if it goes to any of their descendants, we have that age limit of 40 according to the section per stirpes. So when you get to that section per stirpes and it says don't distribute it until age 40, no, that's general. Each of the named beneficiaries of your children are going to end up having their own distribution term listed in. Maybe it is still according to per stirpes. Maybe it's outright. Maybe it's a different age. So make sure when you're going through it, you look at that. Now, what are some common questions? What's this Texas and Florida homestead exemption? We don't have any property in Texas or Florida. This is a North Carolina trust. Well, wait a minute. Yeah, we're really looking out for our clients. We understand that people may move, they may go to different places. And this is just a quick story that I used to give and I still give. If you remember the O.J. Simpson case when he was charged with murdering his ex-wife and another person, Ron Goldman, and he ended up in court. He was charged criminally. His personal attorney said, look, you're going to get sued. Doesn't matter if you're guilty, not guilty, you're going to get sued. So what we're going to do is liquidate your personal assets and we're going to dump as much as possible into a big house in either Texas or Florida. Well, why Texas or Florida? 48 of the 50 states, if you're sued or declare bankruptcy, there's a limit on the value you're allowed to keep for your residence. Texas and Florida they say, no, you get one residence no matter the value. But if you're trying to move those properties into your revocable trust or any trust and you want to retain the homestead exemption, there has to be language inside your trust document. Okay, we put that in there. So it's already there. If you in the future move to Texas or Florida and you put your property into your trust, that provision's already there. You don't have to go and get it redone. All right, trust protector language. Now, this is a wide array that some attorneys may say, well, here's what a trust protector does, and here's what a trust protector doesn't do, and whatnot. We try to keep it simple. This is more about making sure that there is an inexpensive way to resolve some disputes if the beneficiaries think the trustee is doing something wrong. The trust protector can come in, review things. They've got the authority to take control and look at those things. And then their determination is the trustee kicked out or not? And if so, it goes down to the next level. Now, we also, we're potentially looking at making this change. We'll put into the trust that if there are any terms or conditions that need to be clarified because of changing law, that the trust protector can come in and kind of draft that in as just a fail-safe. But that's it. Other attorneys draft trust protector language that says, well, they can come in, they can replace the trustee, they can make themselves the trustee, they can do all this. No. This is just about coming in and having something that is definitely less expensive than court, even less expensive than arbitration, which is for general disputes. Here's just this inexpensive way to just check and verify and make sure the trustee isn't doing anything wrong. All right, trust settlement representative. This is something that we actually came up with. I don't know if any other attorneys are really using it. This is a delegation of authority to a non-trustee to do whatever the trustee wants them to do and have the authority to carry out. The best way to describe how this works is first, what doesn't it do? It doesn't let them distribute money. Second thing is that it's made an appointment by the trustee who may be a very busy person. the scenario that we give as the example that explains it, if you made your son the trustee and he's a very busy person and but you trust him, you want to make sure that your son is the person who's in charge of making all of this happen, but he doesn't have the time to get the house ready for sale, fix up things, organize the repair people or whatnot, but his wife can. There's a form they can fill out this letter, this kind of trust settlement representative letter, and put in here, here's the person, the trust settlement representative, my wife. They're allowed to do all of this stuff related to the sale of the house. Perfect. And once the sale is done, well, the check goes to the trust. Trustee son doesn't need to be there for the walkthrough, handle, contractors fixing things up, doing the sale closing, all that other stuff. They don't need to be there because they can delegate that to the trust settlement representative. This isn't somebody that you are going to appoint. You want your trustee to be able to delegate this stuff as the situation arises. They may not want to. They may want to just do it all themselves, and they can. But this is a way for them to get some assistance and have a legal letter. All right. The other fourth big thing that is a common question: what's this Schedule A? All right. Schedule A is about gifts and loans to beneficiaries, and this is for you to fill out as time goes by. Let me tell you, if you have three children and one of them you're giving $20,000 to, the one you gave $20,000 to is going to say, oh, this was a gift and doesn't get deducted from my inheritance. The other two are going to say, oh no, that was an advance on your inheritance, and therefore we need to calculate that in dividing things up. You're going to get 20,000 less. No, no, no. You can put in the name of the beneficiary, the $20,000, the date, and whether it was a gift, loan, or an advance. So this way, that potential dispute doesn't come up. It's nothing you need to fill out now unless there's already some gift or loan that's out that you've already given and you want to make sure that it's recorded. So, those are the big things with the revocable living trust. Now, like I said, we also have that resource of the audio for the 222 must have provisions, but we can work on that inside the trust. And now, please go ahead, read through the documents, and then bring any questions that you have to the document review meeting. All right, next we're going to talk about the financial power of attorney. Now, that's not really a legal name, but it's the easiest way to understand it because these documents have all these different names. It's a durable general power of attorney, a limited power of attorney, a springing power of attorney, a leaping frog power of attorney. Look, it just matters for, is it active now and is it active after you become incapacitated? Believe it or not, there are actually powers of attorney that kind of end when you become incapacitated. All right. We typically just use a durable general power of attorney. Now, the revocable living trust is designed to handle all of your assets within the trust, but sometimes there are accounts and property and assets held outside the trust, either by accident or by design. So, the type of account most often left outside of the trust is the retirement accounts, IRAs, 401ks, 403bs, all that stuff. Now, as I previously explained, retirement accounts cannot be retitled into the name of control of the trust without losing their tax deferred status. So, in other words, if a retirement account is retitled in the name of the revocable living trust, then it's treated as if the account were withdrawn all in one year, and Uncle Sam wants the income taxes. And so does the state, and any penalties and whatnot. Oh, we don't want to do that. So, this is where a financial power of attorney can come in handy by leaving the retirement accounts outside the trust, listing someone as the primary beneficiary, or naming the trust, or even IRA trusts as primary or contingent beneficiaries. Look, the account maintains its tax deferred status. But what happens if money needs to be taken out when you are incapacitated? the individual can use that financial power of attorney to go ahead and make those withdrawals. It can be listing out. If you're married, it's usually a spouse, or unmarried, it's a partner. But then we have the successor trustee. Look, they're all the same people listed in there. So here are some main items to consider. So, for the most part, your power of attorney agent can do anything and everything you could do with very few limitations. With assets outside of the trust, we don't want to get bogged down with an agent being unable to do certain things, or they must do certain things and they have to do this, because typically, it's taking away good options that your power of attorney agent could be taking advantage of. So, if you leave a long list of must do's or must not do's, maybe it's time to reconsider who you want being that financial power of attorney. Now, another thing, and this pops up occasionally, don't worry about any spouse language in this document if you're not married. Those are references that are there to make clear under the law a power of attorney agent is able to distribute money or change beneficiaries to a spouse if that's what's best under the circumstances. Well, I don't have a spouse. Well, this is just in case you do end up being married in the future. You don't have to redo the documents to add that. The healthcare power of attorney. Now, while the revocable living trust allows one person to handle most financial assets belonging to a sick spouse or partner, or the successor trustee stepping in, the healthcare power of attorney allows the other person to make the medical decisions during incapacity. So, some of the most important decisions an ailing person wants their spouse, partner, or named people to do are regarding medication, hiring and firing of doctors, who gets to visit during hospital stays. Look, the healthcare power of attorney, while far simpler than the revocable trust or even the financial power of attorney, may be one of the most critical documents during a crisis. Now, there's a lot of form language in there. Here's a couple of main items to consider. Now, for the most part, your healthcare power of attorney agent can make any healthcare and medical decisions you could make with very few limitations. Again, we don't want to get bogged down with your agent being unable to do certain things, or they must do certain things. And I had a gentleman, he put in his power of attorney under one of these fill in forms, no amputation. And what he meant was, I'm a type 1 diabetic. If you cut my arm off, I'd rather you let me go. But if you get a little infection right there on the pinky, they could amputate. You could live for another 30 years. Well, that legal document says no amputation, so we're not going to allow you to do that. No. Leave that decision up to your healthcare power of attorney. Now, one big exception to all of that is most of my clients want to put together a living will, because the final decision of taking away life support and artificial nutrition, it's because it becomes an emotional burden that they may carry around for the rest of their lives, and you don't want that part. So, that most of my clients, when we talk about a living room, we'll talk about what that does, but that's kind of the one exception to that broad delegation of power. Now, another thing that occasionally pops up, I've got attorneys, they're fanatical about, you need to have a HIPAA waiver form. You need to have a HIPAA waiver form. Wait a minute, where's my HIPAA waiver form? We draft the language directly into your healthcare power of attorney. So don't be concerned if some attorney friend of yours said, your attorney didn't do a HIPAA waiver form. No, we put it right in the language. Why? Why do you do that? Because when people are going to hospitals, or if there's an emergency, they'll just go and grab the healthcare power of attorney, get there, and they go, well, wait, there's no HIPAA language. Oh, I got to run back and get it. Just draft it right into the document. We also put that language into the financial power of attorney just to make sure your financial agent can get access to medical records, particularly itemization of bills they're expected to take care of or pay. All right, so on to the next document. We have the living will, or as it's kind of laid out in North Carolina, a declaration for a desire for a natural death. All right. This is that specific document laying out your directives when it comes to life support and artificial nutrition and hydration at the end of life. Now, specifically, when doctors determine that you are terminal and incurable, should they remove life support or artificial nutrition or hydration, or both? and let you go. And when doctors determine that you are in a persistent vegetative state, should they remove life support and artificial nutrition and hydration and let you go? Now, this is usually the one decision that people want to take out of the hands of their healthcare power of attorney agents because they don't want them to feel responsible for, quote, offing them. And I've had clients years and years and years later saying they had to make that decision and they still feel guilty about having to deal with doing that for a parent. All right. So this is a form created by the legislature. It's put directly into the North Carolina general statutes. So we highly recommend don't mess around with the language. Now, there are other, quote, more recent forms that will initial if you want this or state this. If you don't want this, then this. No, no, no. Leave that up to your healthcare agent. That's why we still use the old living will form. And again, if you have a whole host of musts or shouldn'ts you want to add to that document, what that's really saying is, I don't trust the doctors. I'd rather have the people I trust with healthcare make those decisions than just don't sign that living will. The decision then defaults to your healthcare power of attorney and they can handle it. Now, don't worry about where to initial or any of that stuff. That's something for the signing. We walk through exactly what those things mean and state here's where you initial. Nomination of conservator form. This is another important document to have as a part of your legal plan. It nominates your conservator. A conservator is a court appointed guardian for you in the event you're unable to handle things yourself for a sustained period of time. Now, the trust and the power of attorney documents and the healthcare power of attorney should be all that you really need to make sure that the people you choose are handling your healthcare and financial matters. However, it's still possible for a judge to stretch their authority or someone else to come in from the outside and say, I don't like what's going on. I'm going to take over. I'm going to do this. I'm going to go to court. All right. At that point, it's critical to have a list of the people, the conservators you would prefer. Now, if you have conservators listed, it becomes even harder for a judge to select someone else if you've got those same people as in your power of attorney, healthcare power of attorney, and trust documents. So please read these two sections carefully since they appear identical if you're scanning. However, one refers to your conservator of the person and names the same people in your healthcare power of attorney. And the other refers to your conservator of the estate, and it's the same people in your trust as successor trustees in your financial power of attorney. You don't want to change the people in these lists without also changing the people in the corresponding documents as well. We want all of our, quote, financial people to run across the trustee list, same order as the financial power of attorney list across the board. The executors in the pour over will are also there. That's the conservator of the estate. It's the same people you trusted with financial things. Now, you also want the people named in your healthcare power of attorney to be the people listed as your conservator of the person. If you have different people listed in either of those categories in the nomination of conservator document than the others, then a judge will say, well, obviously, if it's different people, they wanted a court to take over and oversee all this stuff, and obviously they would have wanted it. Otherwise, they would have named the same people. This is almost guaranteeing living probate, like I mentioned in my book, Estate Planning Basics. You don't want that. So if you're looking at that list and you're saying, hey, wait a minute, I don't know if I necessarily want this person, you should look across the board and we should address that question again at the document review meeting. All right, so we're ready to go on to the next document. This is a pour over will. All properly drafted and executed revocable living trusts take the place of that traditional last will and testament. It does everything that you're supposed to put into writing in a last will and testament, but it's inside the trust. So there is still, even with that, there's a need for a last will and testament called a pour over will. In relation to the other documents, its function is relatively minor if your trust is well funded. However, it can't be overlooked. The only true function of a pour over will is to take assets that may end up in probate and hand them over to the trustee of the revocable living trust to be handled as part of the whole trust estate. If an asset is titled in the name of the trust, then it will not have to go through the probate process before being distributed to the chosen beneficiaries. If it is in the deceased person's name, there's no pay on death beneficiary. All right, it's got to go through the probate process first. The only way to direct the probate assets to the trust is through the terms of this pour over will. However, this brand of will has only the most basic clauses and terms necessary to make it a valid last will and testament. Now, here are a couple of items to consider. The pour over will should not contain the same beneficiaries as your trust. The only beneficiary of your pour over will should be the revocable living trust. Well, why don't we just list all the beneficiaries in the will? Well, because then you're setting up a probate process with multiple beneficiaries that all have to be notified, all have to sign off on forms, and it just becomes a more of a chaos. Unfortunately, I see some probate attorneys, they actually duplicate those terms into the will, and if their clients don't properly fund all their assets to the trust or do some other arrangement, oh, well, they must have missed it. I'll handle the probate, and all this extra stuff ends up being exposed to the public and becomes more expensive. No, it should only be the revocable trust. There's strong language putting the decisions regarding funeral and related plans in the hands of the named executor. Now, why do we do that? It's because that's the person you trust to make rational decisions with money. It makes sense that one person is in charge of it, and it's the person who you trust with money, because there are a lot of people who become very emotional, and it's, of course, we want the gold plated handles on the most expensive casket. They're worth it. No, your financial person's going to make things a little more reasonable. And also, by being named the sole person making these kinds of decisions, it can get around having multiple waivers that need to be signed in order to authorize cremation in North Carolina. Unfortunately, if you don't have this listed somewhere in your will, then all of the next of kin, regardless of who's the beneficiary of your trust, all of your next of kin need to authorize the cremation. And you may not be in contact with all of the family members that are your closest next of kin, and it becomes a big deal. All right, so on to the next document, the trust abstract. The most important thing to realize about this document, it's not a summary of all of the terms of the trust, nor is it meant to spell everything out. I've even had clients say, well, if this is a summary of the trust, why don't we just use this? No, no, no. This is a declaration summary of the specific things that banks and other financial institutions generally want to see. And it's when you're titling accounts into the name of the trust or even pay on death beneficiaries. And it's done without showing all of the beneficiary terms, who gets what, when do they get it. So this helps maintain privacy as much as possible for your estate, while still affirming in a legal document, signed, witnessed, and notarized, what the banks usually want to see. So the main items to consider for this document: this isn't meant to summarize the trust, so no terms are, quote, missing. We only list the first successor trustee in the abstract. Well, why not list all of them? Well, because if you list all of the contingent trustees, there's a high likelihood that the top successor trustee is going to go to the bank, handle this, and say, hey, here's the abstract. Then go, well, no, we need all the co-trustees who are also listed in this document to come in. Well, no, they're down the line. We don't want the liability. We want everybody to come in and sign it. That's not what you want. So we only list the first one. If they pass on, you make changes, we update just that first name. There is a very high likelihood that when the bank asks for a copy of the trust and you give them the abstract of the trust, okay, they'll go ahead and just put it on the file, make sure it says what they want. But there are other financial institutions, they may still want a full copy of the trust. Look, at that point, you kind of have to make a decision. Do you want to disclose that to the bank, or do you want to go ahead and do your banking elsewhere? There's no kind of in between and still effectively handling your trust. The bank may say, oh, well, you can just, no, we don't need a copy of the trust if you want to make the trust the pay on death beneficiary. That may not be optimal. When we get to the trust funding meeting, we'll go through all the different permutations and provide that list of here's what the recommended actions are for each and every account. And in that meeting, we also explain why. But for now, the trust abstract, that's all it's meant to be. Bank wants a copy of your trust? Try giving them this one. A lot smaller, a lot simpler. All right. The assignment of furniture, furnishings, and personal effects. Look, the revocable living trust is only as effective. It's only effective if the assets are inside the trust or set up to transfer into the trust when someone passes on. Now, the assignment of personal effects form transfers assets that do not have a specific title to them in the name of the trust. So, for example, furniture, appliances, clothing, jewelry, books, all that stuff are personal effects without a specific ownership paper or title. That's automatically transferred into the trust. That's an important thing with the questions that come up. It transfers those items into the trust. This is not the case with items such as land and houses, bank accounts, financial account. Look, those all have recorded and titled owners somewhere on there. If the trust is named as a beneficiary in the account, some combination of all that. Okay, above all, simply having the document is not enough. Your assets must work in combination with the trust and other documents to take care of you and your loved ones. So this is something that we do discuss in more detail at the trust funding meeting. And the main item to consider, this doesn't transfer title to cars, bank accounts, or real estate. And the other one is that this doesn't transfer stuff, specific items of property out of the trust. This is only to move it in. Think of it as like a sales receipt that you moved it into the trust. The trust or personal property memorandum in combination with the trust can have those personal items go out to specific individuals. It's not in this document. All right, so the next one, you may or may not have this one. It's the appointment of guardian. So this document may be included in your drafts if you have minor children or you're the official guardian for any disabled adults. This is a list of the people you are recommending a court approve to take over guardianship if you pass on. That's all it really is. But it's worth noting specifically what it does because it's not an absolute appointment like it is with the successor trustees and power of attorney agents and things like that. This is only your best recommendation. When it comes to guardianship, a court always has to make the ultimate decision. Your recommendations go a long way, but they're not absolute. The younger the children are, the more likely a judge is to just approve your recommendation if there's nothing wrong with your choice. Now, if you named a person and since you did that, they've suffered a series of incarcerations or mental health commitments and things like that. Whoa, wait a minute. They may not do that. But then they're more likely to just go to the next person that you've recommended. Also, balancing against this, the older a minor child is, the more likely the court will take into account their wishes in making an ultimate decision. So remember, this decision is completely independent of your decisions on naming financial agents or healthcare agents. It's strictly about naming who would raise your dependents irrespective of who controls the money. And you can make changes in this document without impacting any of those other ones. All right, now, this next document I'm going to talk about is not even included, but we've just had so many questions pop up. Wait a minute, why wasn't this? Whoa, hang on. A trust certification form. This document is not included with the drafts we send because it's a fill-in form that's meant to be signed under very rare circumstances. However, because we get so many calls weeks, months, and even years later, when our clients find this unsigned form in their estate planning binder, they panic a little. Well, wait. This form is meant to be filled out when, one, been a year or several years, you're opening an account or you're refinancing a property, and the institution asks for a copy of the trust. Then they come back and ask, well, how do we know you haven't changed your trust since it was signed? We need you to fill out a form stating that you haven't changed the trust copy that you gave us, or if you did, put what changes were made. And this form is called a trust certification form. In a ridiculously big portion of the time, like not no word of a lie, 99.5% of the time, the financial institution will have their own kind of fill-in form they want you to use. In that 0.5% of a chance that they don't have their own form, well, okay, this is supplied and put into the trust as a form. It makes no sense to fill it out at the time of signing your original trust when it could be 5 or 10 years or more later that the financial institution wants you to certify, signed it in writing if you made any changes. So, wait, that was 10 years ago that I signed it. No, they're going to want a fresh one. In those extremely rare occasions that there isn't a specific form from the institution, most institutions will tell you, oh, your estate attorney can give you that. All right. In those cases, when it's related to a mortgage or a refinancing of a mortgage, look, we'll be happy to custom create a form for you, but only if the financial institution provides to us in writing what terms they want to see addressed in the form. Again, it's in writing and they provide it well in advance of any document closing, typically at least 10 business days. Now, problem in the past was financial institutions were vague or, "Hey, well, yeah, we kind of want to see this and maybe we want to see that." They would never put in writing the exact things. And then a day or two before closing or the day of the closing, this form is wrong. Oh, wait. I did a whole video on this called A Trust Certification Clown Show. It's available on the YouTube channel. Easiest way to get to the channel, youtube.com/NC Lawyer, and search for A Trust Certification Clown Show. So if those conditions are met, they tell us what needs to be addressed. It's in writing. Here's what it is. We'll go ahead and custom create that for you if it's needed. Just contact the law office and let us know. All right, so I hope that gave a little more clarity to the documents. I know we probably covered a lot of this in the estate summary meeting when I went through the different documents. Here's what they are, here's what they do. But now we're at that stage where you're looking at the documents and making sure everything's correct. So I look forward to seeing you at the document review meeting so we can go over this in person for any remaining items, questions, or changes you might have. Now, as I always tell my clients, please stay safe, plan ahead, and enjoy life. And whatever you do, make it a great day.